Do you remember how Supreme Court Justice Clarence Thomas failed to disclose luxury trips by Texas businessman and GOP donor Harlan Crow? Well, to no surprise to anyone, the U.S. judicial body rejects requests to refer Clarence Thomas to the Justice Department. Why? And the reason why is something we've touched upon on this channel. It's something that I've put forth of frustration with the courts. And declining to make a referral to the Justice Department, Conrad cited constitutional questions about whether the judicial conference could do so that require further study. So the problem is jurisdiction. Can the Department of Justice actually have the little Supreme Court justice be referred to it? Now, I agree that there is murky questions as to whether that's possible because it's supposed to be Congress that checks the courts. But again, if Article 3 on the judiciary is incomplete, therefore Congress is the one that creates the laws and regulations that the courts are bounded by, and that's not guided by the Constitution because that's incomplete. It's guided by Federalist 78 through 83, which has originalism, which isn't necessarily in full alignment with constitutionalism of the Article 6 Supremacy Clause. However, what it does, it put forth and highlight a favorite trick of the conservative side, specifically of the judiciary, which is to leverage ambiguity of the Constitution in order to promote their conservative agenda. Why was Roe versus Wade overturned? Ultimately, because there is a question of personhood. However, the burden of proof that a fetus before viability is not just life, but a person, because dogs are alive, but they're not constitutional persons, right? So it has not been proven that they are alive. It's actually inconclusive within science. This means that the courts were putting up women and Americans who could birth alongside an imagined person, and the Equal Protection Clause disallows for that. Within the preamble, it tells us that there is a distinction between we the people who have pure benefits of the Constitution and our posterity, which is all future generations, which will achieve our constitutional protections upon them being born. Now, this is my take on this as to what it means. What we can see, the fact that there is a distinction between we the people and our posterity. We know that because otherwise, why isn't the environmental protections constitutional right? Because can you really restrict the freedoms and liberties of people who currently live because of people in the future? Now, I'm not saying I agree with this logic, but I'm just saying that's a constitutional framework of thinking. Why is the disqualification clause not capable of being executed by a state? Because the court said that it doesn't say it in the Constitution. So again, leveraging the ambiguity of the Constitution to promote their conservative judiciary authority. Like, yo, it's so messy, and all you have to do is look at I believe my third pinned video on the route of the court in order to understand how truly frustrating this is, the fact that we don't actually have a resolution for this because of the ambiguity. The only solution to this isn't actually Congress or even the courts or even the executive, because the executive technically, I would even say that they probably wouldn't have jurisdiction over the Supreme Court, but I'm no lawyer. I only have a legal jurisprudence background, but I do not claim to have that lawyer authority or even advanced intellect. Actually, I push back against that because here in the United States, American justice is obedience to superior orders, while in my background, international law, you can actually reject those superior orders if that is against fundamental lawful rules and regulations. But Article 5, the second method in which to execute the amendment clause, that is through state delegates rather than federal Congress. So much more like the prohibition repeal than the Equal Rights Amendment, because we know the Equal Rights Amendment is still being dragged on. Prohibition was repealed that very same year. Now, the scary thing that progressive put is that the Republicans in a convention of the states is capable of putting forth anything they want, but that's why Congress should have it exhaustive. But then the question is, if it's a majority Republican Party, then wouldn't they put forth their own interests within that constitutional convention? And that's correct. I do believe that this is our only solution for judicial reform. I do not believe that this should be the focus in these next 4 years. Maybe I'm wrong, but I don't want to be reckless. I want to be transformative. I don't want to be reckless. But it's important for you to know this so that you can rage and understand how important it is for the people to truly support such an initiative in the future. Because it is the only method in which we can get judicial reform and get rid of judicial immunity. And actually, I would say depending on how January 6th, for example, right? Depending on what happens on January 6th, I can see that accelerating our capability to actually invoke Article 5 without fear of conservative takeover. But this isn't a judgment that I can make right now. It has to be done after January 6th when we know where we stand in regards to what's going to happen. So I'll keep you updated on that when we get there.